So in Whole Women's Health versus Hellerstedt, the Texas legislature had passed a law which required physicians performing abortions outside of a hospital setting to have admitting privileges to a hospital within 30 miles of where the abortion was performed. And that they also, the abortion clinics themselves, must comply with all sort of surgical standards of ambulatory surgical centers, which are typically considered trauma one sort of standards. That's a fairly high bar for most abortion clinics to meet. In fact, it's a bar that most abortion clinics in the United States don't meet. And the reason why Texas argued that they sought to pass this law was for the health and safety of the mother, that if any sort of unexpected occurrence happened in the process of a procedure, that the physician in question would be able to transfer along with the individual, along with the client, to a surgical center, and the occurrence of complications would be significantly reduced. But they ran into a problem in the areas of McAllen and El Paso. And see, in McAllen and El Paso, the clinics simply did not have the ability to comply with these standards. So the petitioners argued that it denied equal protection, that it was constitutionally arbitrary, it was unreasonable, and mainly it was an undue burden on access. And so the court has to wrestle with this issue. And if you remember in the previous case that we did that dealt with actual abortion rights and access, it was a 5-4 decision in which Kennedy wrote the majority opinion, and it went in a conservative direction. This case is a 5-3 majority decision. It goes in the liberal direction, and Kennedy joins this case as well, joins the majority in this case as well. The reason why it's 5-3 is that in the intervening years, Justice Scalia had passed away and had not yet been replaced upon the court. So it is a 5-3 decision, but even if Scalia had been on the court, it simply would have been a 5-4 decision. And if Scalia's replacement had been on the court, it still would have been a 5-4 decision. It still would have gone in the ideological direction that it did. So the court, looking at the law in question, applies the substantial burden test. And Justice Breyer, writing the majority opinion, argues that the medical benefits that are supposed to have been increased by this law in question do not justify the increased burden on access to an abortion for women. That the provisions, while if you take them facially, exist to increase the health and safety of the mother, is not balanced enough against an individual woman's right to choice. Furthermore, if you actually look at the regulations in question, they don't actually provide that significant of a boost in terms of standards, because abortions are overall exceedingly safe. And so the increased standard of other outpatient surgical centers, or of increasing them above outpatient surgical centers, simply does not track with what is the known legal standard. Justice Ginsburg, during oral arguments, asked an exceedingly interesting exchange, and I want to focus on it a little bit because it very much informs her concurrence. During oral arguments, she asked a question of the Texas Solicitor General, and the question she asked of the Texas Solicitor General focuses solely on El Paso. She asked the Solicitor General how many women in the state of Texas live 100 miles or more from a clinic if the Texas law went into effect. to which the Solicitor General said around 25% of women would live beyond 100 miles of the clinic and therefore wouldn't have access. But he said that that area didn't include El Paso, because despite the fact that El Paso would not have a clinic and therefore would not be within 100 miles of any clinic in the state of Texas, Santa Teresa, New Mexico had a clinic, and therefore they would be able to have access to an abortion in another state. Ginsburg replies, quote, "That's odd of you to point to the New Mexico facility. If your argument is right, then New Mexico is not an available way out for Texas, because Texas says to protect our women, we need all of these things that we've established in this law. But if you live in El Paso, that doesn't apply because you can just go to New Mexico. So the standard is good for everyone in the state of Texas except those women that live in El Paso." And so El Paso features significantly prominently in the oral arguments and also in Justice Ginsburg's concurrence, in which, among other things, she points out this gap that exists within the law, and that if it truly was for the health and safety of the mother, part of Texas's justification for El Paso wouldn't be they can simply go to New Mexico where those standards don't exist. She also notes that modern abortions are in many instances safer than childbirth itself. And so the law requiring reducing access to abortions in the names of safety doesn't seem to make sense at all. In terms of dissents, Justice Thomas dissents, and we're really going to focus primarily on Justice Thomas's dissent. Justice Alito also dissents, but we're going to focus on Justice Thomas. Justice Thomas articulates that at first he has an issue with the standard used. He has an issue with the undue burden standard as used in this test. And he's had an issue with the undue burden standard for a long time. So it's not unique that he brings up that issue in this case. But also he brings up a unique argument about the justiciability of this case. And the issue here is the individuals who are bringing the suit probably shouldn't have standing, because they are the healthcare centers in the case and not the women who would have been denied coverage if those healthcare centers cease to exist. And so his argument is that these individuals don't have standing and therefore the issue simply shouldn't be justiciable. And that's a unique technical legal point, but it's one that is true. However, there's a degree of, does it even matter? Because women who had lived in El Paso or lived in McAllen, which is the other area that brought this suit, could have easily brought the claim on behalf of themselves and not having access. So the issue is, I think, technically legally correct, but also not important with regards to the ultimate outcome of the case. And so here in 2016, we see a majority of the court uphold a women's right again by denying these restrictions on a right to a woman's access to abortion. Now, we sit in 2019 and something very different has happened to the court. Just like we analyze the difference between Stenberg and Gonzalez, and that difference point is O'Connor left the court and Justice Alito joined the court. In 2016, something else has happened. Justice Kennedy has left the court. Justice Kennedy is in the majority of Whole Woman's Health. Justice Kennedy's left the court, and he's been replaced by someone more conservative than him, someone who does not sit ideological in the center. So if we were to have a similar case now, I'm not certain that the majority in Roe would withstand it. And so we're in a situation now where a lot of abortion regulations have been pushed through many states And those states are attempting to test Roe v. Wade, and they'll be coming before the court most likely within the next year or two. And while I don't want to signal the death knell of Roe v. Wade, giving the ideology of the court and giving the majority of the court as it is, I'm not sure if Roe will survive the next 2 to 3 years intact.